Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here today to do a deep. Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we're doing a deep dive into the question of whether Donald Trump's lawsuit against him, the criminal conviction rather, will be taken from Georgia state court into Georgia federal court. This is not normally something that you can do. You can't just normally transfer a state case into a federal case. In some countries in the world, various levels of government hear various kinds of cases. So sometimes people from outside the United States think, a certain kind of case, if it's a certain kind of severity, must necessarily be heard on the federal level. But that's not how we do things in the United States here. There is no severity issue. There's just different charges from the state governments and different charges from the federal government. It has nothing to do with the severity of those charges. You can have relatively minor charges in federal level, and of course you can have very serious charges in the state level as well. So it's all about that. So we're here to discuss whether or not you can take this Georgia state prosecution and what's called remove it, to use the proper nomenclature, into federal court. Now, this analysis has nothing to do with the cases against Trump as it relates to January 6th or as it relates to the classified documents case, because those cases are already in federal court. So we don't have to discuss whether you can take them from state court to federal court because they're already federal. Right? It also doesn't have anything to do with whether or not he can take his New York state case federal. That case deals with his business dealings and has already been determined by the court in that case, and I think quite correctly, the relevant federal statute we're going to talk about doesn't apply because it has to deal with his it has to do with his business dealings rather than things that emerge from his position as president. So this statute works to the extent that he is doing things that are arguably, colorably within the scope of his office. Arguably, colorably something that he could do in his capacity. Whether or not he can do it or not, would have to be decided in a full hearing. But at the moment, all he would have to prove is that he could arguably do this. And so he has not filed these paperwork yet in Georgia, but Mark Meadows has. And so Mark Meadows, who is working as his chief of staff, would have very similar, parallel arguments to Donald Trump. So we will take a look at Mark Meadows' effort to transfer his case from state to federal court in an effort to try to learn whether or not Donald Trump will also be able to take advantage of this move. So let's go ahead and get started with this because this is going to take some time. All right, we are here. We're going to look at 4 documents today. We're going to look at the original notice of removal from Mark Meadows. We're going to look at the opposition to the removal from Georgia. And then the federal court asked a question about what does Donald Trump what does Mark Meadows have to prove in this situation? Does he have to show success as to every single count of the conviction or only elements in the count? So we'll get to that as we go on there. So we'll be there. So, fine. All right, let's go ahead and get started. How many people are here, by the way, just as we get started? I now have to pull up YouTube to see what my count is. 84 people watching? Great. All right, let's go ahead and get started. All right, so Mark Meadows was the former chief of staff to the President of the United States, which, for those of you who don't know, is a fairly prestigious job within the United States government. It's arguably one of the hardest jobs in the United States government because the Chief of Staff runs the White House. That is the organization of the White House itself, right? Donald Trump is President of the United States, not President of the White House, right? So he needs someone to actually run the apparatuses of the White House, which is the Chief of Staff. So it's a pretty big role unto itself because there's quite a lot of people that work at the White House. And also the role tends to be the chief advisor to the United States, to the President. Also, they tend to, as a matter of practice, be kind of like the chief operating officer. So they tend to get the shit done. And they also tend to liaison with a lot of other agencies and stuff. So the job is pretty intensive. It's arguably harder than being president, depending on your point of view. It's a lot. So anyways, he was filling that role for some period of time. And he wants to remove, to use the proper nomenclature, the case to the federal court from the Fulton County State Court. So right now it's in a county, Fulton County, and he'd like to take it federal. Insofar as it charges Meadows in 2 counts of the 41-count indictment. So this isn't as necessarily as to all the counts, but it is to some of the counts, and presumably the rest would come along for the ride. All right, so why does he think he has the right to do this? Mark Meadows argues he has the right to remove the matter. The conduct giving rise to the charge in the indictment all occurred during his tenure and as part of his service of Chief of Staff. This is the critical argument, that what he did as part of his official job function, at least arguably so. In the circumstances, federal law provides for prompt removal of a criminal prosecution commenced in state court against or directed to a federal official in an official or individual capacity for or related to any act under color of office. So if it relates to his service as Chief of Staff, whether it's official or individual, then the federal court should take the case over. That's the argument. The removal statute protects the federal government from interference with operations that would ensue were a state able to bring arrest and bring trial in state court for an alleged offense against the state. So the principal reason that this exists is because of federal supremacy. The federal government has supremacy over the state government. So states can't make legal what the federal government makes legal. It wouldn't make any sense. The states don't get a veto button on all things federal by just simply passing a law that says, well, we don't like when the federal government does X, whatever that might be. So if they do X within our state, we're going to arrest and prosecute them. It's like, this doesn't make any sense. This doesn't make any sense. The states don't get nullification power. We fought a war over it. So you can't do that. And so that's the idea, right? We're going to take this to federal court because they are trying to interfere with a federal job function in the executive branch. Okay. Nothing Mr. Meadows is alleged in the indictment to done is criminal per se. So they gave a whole bunch of overt acts that he did. And he says that none of those overt acts are in and of themselves criminal. Which, they're not. So legal acts can be part of an illegal course of action, right? If I go rent a car, which is legal, but I rent it for the purpose of being the getaway car for a bank robbery, it is an overt act in furtherance of the illegal goal. So it's perfectly legal to rent the car, but if it's part and parcel of the illegal activity, not as much, right? So he argues that all the acts are legal unto their own terms, which I think is fair. They are probably. The acts that he is alleged to have done are arranging Oval Office meetings, contacting state officials on the president's behalf, visiting state governmental buildings, and setting up phone calls for the president, which sounds pretty typical for Chief of Staff. One would expect the Chief of Staff for president to do these sort of things, and has far less to do with the interests of state law than, for example, murder charges that have been successfully removed. So they refer to some cases from the past, 1890, 1879. I'm not sure when the last time this was successfully done was, by the way, in the criminal context, but it's been a hot minute. So, even cases that, are murder, if they relate to the official job function, are taken by the federal government, which, fair enough. This is precisely the kind of state interference in a federal official duties the Supremacy Clause of the Constitution prohibits and that the removal statute shields against. Mr. Meadows intends to file a motion to dismiss in the indictment pursuant to the rules, which he did. He filed a motion to dismiss on the basis of official act immunity. Mr. Meadows respectfully requests the court to hold an evidentiary hearing to be held promptly and dispose of the prosecution as justice was required, which they did hold the evidentiary hearing, a transcript of which I still have not gotten a copy of. Here, justice requires the prompt dismissal of the charges against Mr. Meadows. At a minimum, in the meantime, federal law requires granting removal, which will halt state court proceedings against Meadows while the motion dismissed is resolved. So until the federal court grants the motion to remove, the state court proceedings proceed. There is no stay on the state court proceedings while the federal government is figuring out whether or not they want to take the case over, which is kind of a weird thing in some ways. I mean, there might be a logic behind it, but it's just really weird because if the federal government does wind up granting removal, then everything the state government goes to naught, which has got to be really frustrating from an administration of justice perspective. I mean, could you imagine that, they go through all the preliminaries and they go through all the motion practice and they're ready to start selecting a jury, and maybe they're in the middle of jury selection, the federal government be like, yoink, ours, and all that just goes away and all of it goes poof. Kind of what a waste of time. So the sooner the federal government can resolve this, the better. This matter, insofar as it relates to charges against Meadows, arise directly from service as Chief of Staff. Mr. Meadows served in the role from March the 31st, 2020 until January the 20th, 2021. So he served in the role for about 9 months, which, fine. Sometimes it's shorter, sometimes it's longer. I don't think any Chief of Staff usually lasts a very long time. It's usually considered a very taxing job. So I'm not sure what the record for a modern Chief of Staff is, but they tend to drop like flies. It's a tough role. Before that, he served, and maybe particularly hard for Donald Trump, but just generally. Before that, he served as a member of the U.S. House of Representatives from January the 3rd of 2013 until March the 30th of 2020, which he decided to then take over as Chief of Staff until, I guess, President Trump's term came to an end. The events that gave rise to the indictment during Mr. Meadows' tenure as White House Chief of Staff are directly related to that role. The indictment sets forth the following factual allegations, and only the following factual allegations as they relate to Meadows. So Meadows says that every one of these things happened during the time he was Chief of Staff and are related to his role of Chief of Staff. So therefore, he should be protected under his federal role because he was doing his job, quite literally, and it's a federal job. And so the state can't make legal what the state can't make illegal what the federal government makes illegal, or whichever way that was supposed to be around. All right, so here's what Georgia has alleged. On or about the 20th day of November 2020, Donald John Trump and Mark Meadows met with the majority leader of the Michigan Senate, Michael Shirkley, Speaker of the Michigan House of Representatives, Lee Chatfield, and other Michigan legislators in the Oval Office at the White House, and Donald Trump made false statements concerning fraud in the presidential election. On or about the 21st day of November, Mark Meadows sent a text message to the U.S. House Representative Scott Perry from Pennsylvania and stated, "Can you send me the number for the Speaker and leader of the Pennsylvania legislature? POTUS wants to chat with them." It seems pretty banally clerical, right? On or about the 25th day of November 2020, Donald Trump, Mark Meadows, Rudy Giuliani, and Jana Ellis, and unindicted co-conspirators, whose identities are known to the grand jury, met with a group of Pennsylvania legislators at the White House and discussed holding a special session of the Pennsylvania General Assembly. On or about the first day of December 2020, and the 31st day of December 2020, Donald Trump and Mark Meadows met with John McEntry and requested that McEntry prepare a memorandum outlining a strategy for disrupting and delaying the joint session of Congress on January 6th, the day prescribed by law for counting the votes by the duly elected and qualified presidential administration. Which isn't necessarily illegal, by the way, depending on exactly what you want the memo to do. If the memo is prepare for me a legal strategy that would allow me to further my aims, even if the ultimate answer is, well, I can't think of anything, right? Asking you to prepare a memo isn't necessarily in and of itself illegal. So if you came to me as a lawyer and you said, could you prepare a memorandum for me outlining a strategy for doing X, right? And I would be like, yes, I can. And then I would go look into the legal aspects of what you wanted me to do, and I'd prepare you a memorandum. That memorandum may be anything from, you can't do this, there is no way this can be done, towards to, okay, here's something else you could do, towards, okay, you can't quite do it that way, but maybe you can do something similar this way, to it's fully legal, to whatever the case would be. But simply asking someone to draft a memo that outlines a strategy isn't necessarily illegal, because, how do you know until you start working on it? I don't know. On or about the 22nd day of December 2020, Mark Meadows traveled to Cobb County Civic Center in Cobb County, Georgia, and attempted to observe signature match audit being performed there by law enforcement officials from Georgia Bureau of Investigation and the Office of Georgia Secretary of State, despite the fact the audit process was not open to the public. Which, at this point, he's not exactly a member of the public. So whether or not he can be admitted or not, I don't know. But him going down there and attempting to enter, and they throw him out the door like you're not allowed in. Yeah, okay. While present at the center, Mark Meadows spoke to the Georgia Deputy Secretary of State, the Office of the Georgia Secretary of State Chief Investigator, Georgia Bureau of Investigation agents, and others who prevented Mark Meadows from entering the space. So he drove down there in order to observe something. They said, you can't come in. You're not authorized to be here. Did he force his way in the doors? Did he fight them? It's like maybe they thought that he'd admit him, being the White House Chief of Staff, but they didn't decide not to admit him. So he drove down there with the hope maybe they would let him in, and they didn't let him in the door. And then he talked to some people being like, please let me in the door. And they're all like, nah. So it's not obviously illegal, right? On or about the 23rd day of December 2020, Donald Trump placed a telephone call to the Office of Georgia Secretary of State that had previously been arranged by Mark Meadows. During the call, Donald Trump falsely said he won November 3rd presidential election by hundreds of thousands of votes and stated to Watson, when the right answer comes to you, I'll be praised. Which isn't obviously illegal. He's not asking him to do anything about it. He's just stating his opinion and saying when the truth comes out, you'll recognize it. And also, why is it illegal from Mark Meadows' point of view? Or obviously illegal from Mark Meadows' point of view. On or about the 27th day of December 2020, Mark Meadows sent a text message to the Office of the Georgia Secretary of Chief Investigator, who stated in part, is there a way to speed up the Fulton County signature verification in order to have the results before January 6th if the Trump campaign assists financially? Is there a way to speed up the verification process? How is that illegal? We'll pay for it. How's that illegal? I don't know. Kestrel suggests the Hatch Act. I mean, I don't see how that is trying to change or tamper with the election results. I don't see a violation of the Hatch Act here, but maybe someone else can see it to me. This doesn't seem, is there a way to speed up the election and it's not overtly illegal? And I don't see a violation of the Hatch Act, but maybe it's just me. On or about the second day of January 2021, Donald Trump and Mark Meadows committed the felony offense of solicitation of violation of an oath by a public official in Fulton County by unlawfully soliciting, requesting, and importuning the Georgia Secretary of State, a public official, to engage in conduct constituting a felony offense of violation of oath by unlawfully altering, unlawfully adjusting and otherwise unlawfully influencing the certified returns of the presidential elections in willful and intent violation. By doing what exactly? What did he do to do that is unclear. And then they say that they committed the crime of soliciting the Georgia Secretary of State, but they don't say how. So, like, what did he do? Is not specified. The charge's conduct comprises act taken by Meadows, whether in individual or official capacity, under color of role as Chief of Staff to the President of the United States. Okay. As is apparent from the face of the indictment, as part of his official duties as Chief of Staff, Mark Meadows arranged meetings for the President at the White House and communed with state officials and lawmakers. Mark Meadows went to a site in Fulton County where the chief investigator was conducting an audit of the results of the 2020 presidential election because, and only because, he was serving as Chief of Staff. He wanted to report to the President on how the audit was proceeding and told him the following day that Georgia officials were conducting the work in exemplary fashion. Shortly thereafter, Mark Meadows, in his role of Chief of Staff, arranged a phone call between the President and Georgia officials, including Secretary of State and Chief Investigator. These and other acts form the basis of the charges against Mark Meadows, all fall squarely within his conduct as Chief of Staff. 10 gift donations from Angie Torres. Thank you very much for the gift donations. They are extensively appreciated. Mark Meadows has defenses to the charges of the Georgia indictment that arise under federal law, including federal immunity defense under the Supremacy Clause of the federal Constitution, which, to the extent he's performing his federal role, one would imagine. For the purposes of removal, it is enough the defendant has a plausible federal defense. Another way is to say colorable, which is another way to say that is non-frivolous. Another way to say that might be viable, right? So we're looking for something like 5 to 10%. We're not looking for much. We're looking for anything that's plausible, anything that's non-frivolous, anything that's not ridiculous, anything that won't get us laughed out of court. So he only needs to be able to show something like 5 to 10% confidence that he has a defense that emerges from his role, which, seems like it does kind of on its face to me, to be quite honest. Here, the charges against Meadows far exceed the low threshold. Indeed, as explained below, it's clear from the face of the indictment the charges against Meadows should be dismissed. But for purposes of removal, the court not need to make that determination, which it doesn't. Right? The court does not need to make the determination at this point as to whether or not the charges should be dismissed or not. The only question at the moment is removal. And then once removed, we might get into the question of dismissal. But that's a question for a different day. Mr. Meadows is entitled to remove his actions to federal court because the charges against him give plausible rise to a federal defense based on his role at all times in the White House Chief of Staff to the President of the United States. So, yeah, I tend to agree, right? We're not looking for very much here, right? You can say, the Hatch Act, and maybe you're right. Maybe it is a violation of the Hatch Act. Maybe you're right. But the question isn't whether it's a violation of the Hatch Act. The question is there an argument it's not? Right? Is there a non-frivolous argument it's not a violation of the Hatch Act? Is it a non-frivolous argument that he was acting within the proper role of Chief of Staff, that he has a available federal defense? So it may ultimately be the case, maybe, that he was violating the Hatch Act. But for the purposes of taking this to federal court, the question is, does he have a plausible, non-frivolous, colorable, realistic federal defense? And so, when you look at it that way, and you answer that question, the answer seems obviously yes. Patty says, you're smart and trusted. You'll get so much support if you follow this. You know that? Well, I don't know whether I will or not, Patty, to be quite honest, because there's a strong possibility at some point I'm going to have to tell people something they don't want to hear, which I've had to before and gotten a lot of resistance. For example, I've expressed the opinion many times that I think Donald Trump has a lot of problems when it comes to the classified document case in Florida. I think he's kind of screwed. None of the defenses work. They all fall apart. None of his defenses work. He's basically on tape, basically admitting to the crime on tape, literally saying, yes, I'm doing the thing, ha ha ha. He's one step away from twirling his villain mustache. So, I'm not here to defend Trump. I'm just here to analyze the law as best as I understand it. And so, I'm not sure the degree to which people will support me or not, to be quite honest. All I can do is give an honest legal opinion and be like, this is what I think and this is what I think the law says, and go from there. So we'll see. All right, let's read on. No, Wim, this is not live. This is a pre-recorded stream. Consistent with the requirements of law, Mr. Meadows is filing this notice before trial and not later than 30 days after arraignment, and the grounds for removal are set herein. This notice is filed in the district and division which prosecution is pending. Is signed by counsel pursuant to rules and contains a short and plain statement of the grounds. No process, pleadings, or orders have yet been served upon Meadows in the action, but this notice also includes an attachment to the publicly filed indictment which sets forth the charges. While removal can be initiated later in the criminal process, the filing of the indictment has commenced for criminal prosecution in state court at the time of the indictment, triggering the right to removal. So basically, he filed for this effectively immediately. Thank you, Angie, for your 10 gift memberships. The filing of this notice does not automatically stay state court proceedings, except a judgment of conviction shall not be entered while the notice remains pending. So the entire trial could theoretically happen in state court, and you could even get back a jury verdict, theoretically, that says guilty. The only thing that they can't do is actually enter the judgment. So it doesn't stay proceedings, which, again, has got to be like one kick in the teeth. Could you imagine this entire trial happening, witnesses being called, experts being called, jury deliberations, a jury comes back with guilty, and the judge can't enter the verdict? And then, maybe the federal judge says, yoink, removal, and everything just disappears. Everything just disappears. Because until there's a judgment, it's not final. So everything vanishes. Mr. Meadows respectfully, thank you, Sandy, for 20 gift memberships. Mr. Meadows respectfully asked the court promptly hold an evidentiary hearing, which they did, and either dismiss the charges outright based on Supremacy Clause, which they're not going to do at this time, I guarantee you, or at a minimum, grant removal and notify the state court so as to halt proceedings, which is more likely. The relevant law provides that if the court does not order summary remand of a removal prosecution, which they didn't, then shall hold an evidentiary hearing to be promptly done, which they did. Mr. Meadows respectfully submits that, at most, just disposition is for the charges against him to be properly dismissed pursuant to the Supremacy Clause. The basis for the conclusion is apparent from the facts of the case and the face of the indictment. Even if the court is not prepared to dismiss outright at this early stage, however, justice requires granting removal and halting any further actions against Mr. Meadows. This will allow timely consideration. This will allow timely consideration of the defenses, including the defenses under Supremacy Clause, without having him defend himself in state court simultaneously. First, the court should promptly make disposition of the prosecution as justice shall require. By dismissing all charges against Meadows, the chief of staff of the president at the time of the alleged conduct, the Supremacy Clause provides that this Constitution and the laws of the United States which shall be made pursuant thereof shall be the supreme law of the land, and the judges of every state shall be bound thereby, anything in the Constitution or laws of any state notwithstanding. Thank you, Sandy, for the gift memberships. As always, they're appreciated. The Supreme Court has long interpreted the Supremacy Clause to provide federal officials for immunity from suit involving state charges in order to protect federal operations from chilling effects of state prosecution. The states have no power to retard, impede, burden, or in any manner control the operation of the constitutional laws enacted by Congress to carry into execution the powers vested in the general government. Thus, while the police power, which is the general power to do stuff, includes the power to define and punish crimes, is generally reserved to the states, the power may not be employed against the federal government to exclude it from the authority conferred upon it by the Constitution, obstruct its officers, withhold from it, for a moment, the cognizance of any subject to which the instrument has committed it. So long story short, states get the power to make things illegal, but not things that the federal Constitution makes legal. So you can't make illegal what the federal government makes legal. Bongo Silvio says he's not guilty of any charges in Florida. Y'all wrong. I sharply disagree. I think he's very guilty of the charges in Florida. He clearly was in possession of classified material at a time he was not authorized to possess them. He made no effort to declassify them that anyone can find. He admitted on tape that he had not declassified them. He could have declassified them but didn't, as he was showing the classified documents to a person who was not permitted to perceive them. So basically all of his defenses go away. He knew they were classified. He's on tape admitting to that they're classified. He's on tape admitting their classification. He's on tape admitting he could have declassified them. He's on tape admitting he didn't declassify them. And he's on tape showing them to a person who's not authorized to see them. That kind of covers it. Like there's nothing left. It all goes away. He's effed. States are thus proudly prohibited from bringing suits under state law against federal officials carrying out their executive duties. The Supremacy Clause serves to prevent state law or state law officials from interfering with or otherwise impeding federal officers as they perform lawful duties authorized by federal law. Federal officer immunity has been widely recognized and applied robustly, including in cases from 2nd, 5th, 6th, 9th, 10th, and 11th circuits, which, not surprisingly enough. Thank you, $25 from Jennifer from PayPal. Thank you very much for that. Barnes is still game. Barnes is wrong. A federal official is entitled to immunity if he was authorized to do what he did by the laws of the United States, if it was his duty to do it as an officer of the United States, and if, in doing that, he did no more than what was necessary and proper for him to do so. At a general level, the inquiry turns on whether the officer's acts have some nexus which will further federal policy and can reasonably be characterized as complying with the full range of federal law. While the phrase "no more than necessary" might suggest a narrow scope of immunity, that's not how the courts have looked at it. They've unanimously held the federal authority is a question of the officer's general role and authority, not specific authorization. So that sounds a lot like the necessary and proper clause, like not strictly necessary. So a little bit more than that. Here, it's unmistakably clear the indictment charges Meadows with alleged state crimes based on act he took as Chief of Staff to the President of the United States in the course of his duties. No. Screen? That's not what I want at all. Stretch the screen. That's better. I'll lock that in place too. Make the background look nice. Okay. Here, it's unmistakably clear the indictment charges Meadows with alleged state crimes based on acts he took as Chief of Staff to the President of the United States in the ordinary course of his duties. He's therefore entitled to immunity from suit under Supremacy Clause. In order to make the disposition of the prosecution as justice shall require, they should dismiss all the charges. Second, even if the court is not prepared to rule summarily on Meadows' Supremacy Clause, which they totally are not, it should at a minimum promptly accept removal in order to stay the court proceedings against him. By statute, the court is directed to promptly consider whether to accept removal, and whenever the court determines that removal shall be permitted, it shall notify the state court, which shall proceed no further. Mr. Meadows' entitlement to removal is clear. It does not turn on any disputed facts, which, fair enough, because for the purposes of this motion, he will accept that they're true, right? Based on what Georgia says, I should win. The standard for removal, moreover, is easier to meet than the standard for asserting a substantive federal defense. Explain that removal was proper when a federal defense was plausible, and thus separating the actual merits of the defense. Yeah, again, right? So the standard for removal is even easier than actually offering the defense in the first place, because in the first instance, we're only interested in what's colorable, right? We're only interested in colorable defenses. So it may be eventually that we determine that the defense is no good, and maybe it won't even get submitted to the jury, because we'll kick it out at a later stage. But at this point, we're trying to even say if it has any whiff of plausibility, which it does. So hopefully that clears some of that up at least a little bit. To the 170 of you currently watching, I hope you're enjoying this content, by the way. I hope you enjoy this deep dive legal analysis, trying to provide you good quality content as always. And I'm glad you're here, and we'll try to deal with this one step at a time. Prompt importance is also important to stay in the state court proceedings. The Supremacy Clause provides immunity from suit rather than mere shield of liability. The issue should be decided early in proceedings so as to avoid requiring a federal officer to run the gauntlet of standing trial and having to wait until later to have the immunity issue decided. Requiring Meadows to litigate his defenses in parallel in state court would inflict the very injury the Supremacy Clause immunes, both for Meadows and for the sake of other officials. So yeah, it is a little bit weird, and also leads to this very weird possibility that they come to conflicting judgments, which in that case the federal court wins. It's just kind of like a waste of time. Like the state court says no to everything, and the federal court says yep, and then just like undoes everything, right? It's such an inefficiency. I'm not sure why they wrote it this way, but they did. So the court shall admit proceedings, and that is all there is that, right? So it's very sort of bare bones, very basic, because you don't need very much. And I do appreciate an attorney who doesn't write more words than they need. I appreciate that, right? I appreciate someone who doesn't necessarily go into long, winding recitations of just like everything on the face of the earth. So we did it in 13 pages. More realistically, we did it in 12. And I'm, double spaced. And I'm like, I'm here for it. I'm here for it because it's easy. Clear, concise, to the point. What more needs to be said, really, right? All right, so Georgia wrote back pretty much an equally concise thing in the view of 17 pages. Well, no, that's the wrong one. Sorry. They wrote back an almost concise thing in 18 pages. So they almost did it as quickly. So let's read what they have to say about the whole thing. Okay. Chances of Trump getting a Democrat on the jury in FT, Pierce, Florida, almost nil. Well, in federal court, it would be the entire federal district, which covers quite a large part of the state. So, what's the Southern District of Florida? So it covers like half the state. So, yeah, and this covers the Northern District of Florida, which is like a third of the state. So your chances of getting a Democrat, not too bad, because the federal districts are so wide. Of course, you're probably going to get Republicans too, because they're so wide. They're so much more. They're so bigger. So yeah. I'm sorry. That's the supplemental briefing. We'll get there in a minute. 22 pages was the right number. So let's see what the 22 pages is, and then we'll get to the supplemental. I'm sorry you don't care about any of this. Defendant Mark Meadows has asked this court to remove his criminal case from Fulton County to the Northern District of Georgia because the defendant faces charges that do not arise from conduct under the color of his office. That's what Georgia thinks. They don't arise from under color of his office. And because he can offer no plausible federal defense, the state of Georgia respectfully requests this court remand this case to Fulton County. The defendant is a former chief of staff of the President of the United States, and his lack of care for the lawful scope of his duties is a matter of record. Federal law prohibits employees of the executive branch from engaging in political activity in the course of their work. The law in question, known as the Hatch Act, bars federal employees from using his official authority or influence for the purpose of interfering with or affecting the election, which I will read with specificity, because it has to be understood with specificity, right? You can't use your federal official or authority or influence for the purpose which suggests purposefulness, intent, right? So not that it has that result, but for the purpose of interfering with or affecting the result of the election. So you have to show one of those two things, which arguably Meadows can say he didn't do those things, at least as to some of those things, right? Is asking the Pennsylvania legislature if they'd like to have a special session interfering with or affecting the results of an election, is wanting to observe the voter process in place, interfering with or affecting the results, is wanting to speed up signature verification, interfering with or affecting the results of an election. So not sure it necessarily is those things. On November the 9th of 2021, the Office of Special Counsel issued an investigative report finding prior to election day, during Donald Trump's campaign, the defendant and at least a dozen other Trump administration officials did precisely that. And while the specific facts of each case are different, they share this fundamental commonality. Senior Trump administrations chose to use their official authority not for legitimate functions of the government, but to promote the re-election of Trump in violation of law. Which isn't what it says exactly. It doesn't say promoting re-election. It says interfering with or affecting the results of the election, which seems to be a little bit more narrow to my read. The report concludes that from the OSC's perspective, administrative attitude towards the Hatch Act compliance was succinctly captured by then Chief of Staff Mark Meadows, who said during an interview that no one outside the Beltway really cares about Trump officials violating the Hatch Act. It's therefore unsurprising the defendant now petitions the court to remove the prosecutions from the pending cases in which he stands accused of participating in a criminal enterprise that conspired to overturn Georgia's 2020 election in favor of Trump, invoking his status as a former federal officer. The defendant's indictment in the case results directly from his disregard of lawful scope of his official duties, a disregard which now forms the basis of his notice of removal. Indeed, the defendant now expressly states that all the relevant conduct was impermissible political activity, which, is a little bit depending on how you characterize it. Because the defendant was not acting within the lawful scope of federal authority during any of the described indictment, and because he can offer no plausible defense for his actions, the state of Georgia respectfully asks that removal not be permitted. Thank you, Magic Monster, for the nice gift memberships. They are extensively appreciated. Thank you very much. The defendant seeks to remove his pending case under relevant law on the basis that at the time he engaged in the conduct described in the indictment, he was a federal officer under the relevant law. Federal officer removal is available to any officer, agent, or agency of the United States for any act under color of office so long as they can raise a colorable defense arising out of its duty to enforce law. The removing party bears the burden of demonstrating that removal is proper, and if the non-removing party appropriately challenges the facts presented in notice of removal, the removal party must support its facts by competent proof. Defendant cannot satisfy either element. Count 1 of the indictment alleges that the defendant, while associated with a criminal enterprise, unlawfully conspired and endeavored to conduct and participate in the enterprise through a pattern of racketeering activity, both directly and indirectly. The conspiracy contained a common plan and purpose to unlawfully change the outcome of Georgia's presidential election in Trump's favor. Thank you for the 200 of you who are now watching, by the way, just checking the count. Glad to see that so many of you are here. The conspiracy contained a common plan and purpose to unlawfully change the outcome of the election in Trump's favor. Count 28 charges the defendant with soliciting Georgia Secretary of State Brad Raskenberger to violate his oath by unlawfully altering, adjusting, or otherwise influencing the certified returns. See, I'm not necessarily sure should be based on how Georgia necessarily characterizes it. Like, Georgia says that that's what it is, but is that what it is? And does he have an argument that it's not that? Right? Does he have a defense that it's not unlawfully altering, adjusting, or otherwise influencing? Right? And again, like, what the thing thing that's prohibited by the Hatch Act is, where did they put the exact language? Interfering with or affecting the result of the election. Interfering with or affecting the result of the election is what's prohibited by the Hatch Act, which isn't exactly the same thing that you did. All right, so let's read a little bit more. In seeking to remove the case, the defendant must make a showing that he's a federal officer subject to criminal prosecution for or relating to any act under the color of office. The phrase relating to is broad and requires only a connection or association between the act in question and federal office. This is true. This is true. That's one of the reasons I think Meadows probably has the better end of the case, right? Relating to any act under color of office just requires a connection or association with. It's written in pretty loose language, right? It sounds pretty loose to my ear. So it's written very broadly, it seems. So, that's how I read it. This is not typically a high bar to clear. I agree. However, not every act on behalf of a federal officer is an act under color of office. The person seeking the benefit of federal officer removal should be candid, specific, and positive in explaining his relation to the transaction, growing out of where he's been indicted, and showing that relationship was conferred to acts as an officer. The defendant asserts that the conduct charged comprises acts taken by Meadows, whether in an individual or official capacity, under the role as Chief of Staff to the President of the United States. And then, like, your own kind of, it's a weird thing. The defendant then characterized the conduct at issue at arranging meetings for President and communicating with state lawmakers and officials, traveling to Georgia in order to report back to then President Trump about the status of an ongoing post-election audit, and arranging phone calls between Trump and Georgia officials, including the Secretary of State and the Secretary of Chief Investigator. The activities defendants asserts fall squarely within the conduct of the Chief of Staff. How do you guys like the volume level, by the way, on this stream? I was messing with the volume settings. And it looks good on my end, but see, it looks like I'm hitting where I sort of want to in sort of the audio mix, but I thought I'd ask how it's hitting your ear. Is it good? Loud? Too loud? What do you guys think? It's good? Excellent. Fantastic. Compression settings are working. Great. In notice, the defendant makes no mention of the fact that a single one of his activities gave rise to the indictment constitutes impermissible political activity to which a chief of staff may not lawfully perform under color of office. As noted above, federal law forbids any official of the executive branch from using his official authority or influence for the purpose of interfering with or affecting the results of the election. Federal employees are expressly prohibited from using their official title or position while participating in political activity, which is defined as any activity directed towards success or failure of a political party, partisan group, or candidate for partisan federal office. This is precisely what the defendant is charged with doing, and he does not dispute it. In fact, he's readily admits it. In his motion to dismiss, which we didn't cover separately, the defendant unreservedly declares that all the alleged conduct as to Mark Meadows relates to protected political activity that rises at the heart of the First Amendment, and all substantive allegations in the indictment concern unquestionably political activity, and thus, if not covered by the Supremacy Clause, the charges would be barred by the First Amendment. Activities are either political or not. Defendants acknowledge that the activities at issue are unquestionably political because they clearly are. However, defendant does not cite or even acknowledge the Hatch Act, the federal statute explicitly forbidding such political activity for executive branch officials acting or appearing to act under the executive authority. Having admitted that all the pertinent act is political, the defendant has acknowledged that all of his acts falls outside the scope of duties and color of office because he could never, as chief of staff, engage in political activity without violating the federal statute. Which, is one way to read it, but I'm not necessarily sure is the correct way to read it. Also, this, of course, says that the Hatch Act itself is necessarily constitutional, which is another discussion for another day as well. You know, can it really be constitutional, for example, to prohibit, for example, federal officials from running for office? You know, that doesn't make quite sense. Even if it does not, however, the defendant is accused of joining a conspiratorial enterprise that sought to overturn an election, as well as soliciting a general state official, or Georgia state official rather, to violate his oath of office by somehow altering or affecting the election returns. It's not clear, and defendant offers no explanation, how such activity could fall within color of office of chief of staff. In his notice, the defendant's cursory examination of the activities directly referenced in the indictment ignored their plainly political nature, a fact he went on to clearly admit in his motion to dismiss. Count number 1, Act 5, concerns a November 20th, 2023 meeting between the defendant, Mr. Trump, and a collection of Michigan legislators in the Oval Office. Mr. Trump used the meeting to make a series of baseless and false claims about fraud in the Michigan presidential election, saying it cost him the election, which, by the way, the Hatch Act doesn't apply to Trump. So, if Trump made those comments, he's not bound by the Hatch Act. So, you know. The legislatures contradicted Trump, which then allowed Rudy Giuliani, serving as attorney for Trump and personal attorney to Trump, to join in by phone in order to continue that. Giuliani was not working as a federal official, so also not bound by the Hatch Act. The defendant was present for the entire meeting. The defendant's participation in the meeting was clearly political. Merely by being present in the meeting, he's engaged in political stuff. I don't know, man, right? I mean, that seems odd. The president is not bound by the Hatch Act. Giuliani is not bound by the Hatch Act. And all they said was Meadows was there, which, by the way, isn't typically enough for criminal liability in any instance. You can be present at a crime and not guilty of the crime. Mere presence is not typically enough. In fact, I'm not sure it's ever enough. Mere presence, unless like the crime is in the nature of the presence, like trespass, like so then your mere presence would be illegal, but that's in the nature of the crime. Otherwise, I'm not sure where mere presence is illegal. You know, if I'm like with you in a room and I watch you stab a guy, I didn't violate the law. I don't have to help. If I help you with the stabbing or the covering up or anything, then, you know, that's a problem. But if I choose to just do nothing, that's not illegal. You know, my mere presence at a crime scene is not illegal. And so they're trying to use his mere presence, that he was present at the meeting, as that he's doing it illegal, which seems odd. It seems very, very odd. Tony asked, would Meadows have any legal impetus to correct the statements? No, he wouldn't. He has no duty to correct the statements. No, why would he? Trump is the one making the statements to the legislatures. Trump is his boss. His duty, to the extent it exists, is to Trump. So Trump is the one making the statements. He has no duty to the Michigan legislatures, no. So it doesn't make any sense. As noted in Count 1, Act 6, the very next day after the meeting described, defendant asked congressmen to connect him with the legislatures because Trump wanted to chat with them. This was clearly a political activity. Is it? Is it clearly a political activity? I want to chat with the Pennsylvania legislature. That's clearly a political activity. Can you think of any reasons the President of the United States might want to talk to a Pennsylvania legislature other than a political activity? I can. And also, incidentally, by the way, as I mentioned, the Hatch Act doesn't apply to Trump. So can I get the phone number? Is just, how can the president contact you for the political meeting? So the Trump can, you're saying that Trump can make the call for the political reason, but him knowing that's political, he can't get a phone number for the guy? That doesn't make any sense to me. Patty asks, who's effed? Trump is effed, as is so far as it relates to the Florida classified documents case. Trump is effed, was what I was saying. Count 1, Act 9 concerns defendant's participation in a separate meeting with another group at the Pennsylvania legislature on November 25th, 2020. In the meeting, Mr. Trump personally thanked these legislatures for supporting claims about supposed election fraud in Pennsylvania earlier that day, and he discussed them with the possibility of holding a special legislative session for the express purpose of unlawfully appointing presidential elections. Defendant's participation in the meeting. How did he participate in the meeting? Everything you're referring to is something Trump did. How did Meadows participate? Was he just simply there? Being there isn't good enough. Count 1, Act 9 concerns a meeting between the defendants, Mr. Trump, and John McEntee, the director of the White House Presidential Personnel Office. Defendant and Mr. Trump asked Mr. McEntee to prepare legal arguments and strategy designed to allow Vice President Mike Pence to disrupt or delay the counting of the electoral votes. McEntee did so at the behest of the defendant and Trump. This was clearly a political act. I don't know about that one either. The defendant asked McEntee to prepare legal arguments and strategy. Is that a political activity? Prepare legal arguments and strategy? The vice president works for the executive branch. Donald Trump is the head of the executive branch, and he wants to find a legal strategy. So, like, can you find me a way to do this legally? Okay. Count 1, Act 92 describes the defendant's unscheduled arrival at a location of an ongoing signature match audit being conducted by the Georgia Secretary of State. Georgia officials, including the Secretary of State's chief investigator, prevented the defendant from entering the area. The audit concerned evaluation of ballot signatures and no connection to any federal executive branch duty or power. What? The President of the United States might have an interest in seeing that federal elections are conducted in a fair and reasonable way, and saying, can I send someone there to look at them, seems perfectly proper. I don't get it. As described in Count 1, Act 93. Randy asked what they do differently from Clinton's team in 2016. I don't know enough about what Clinton's team did in 2016 to intelligently answer your question. I don't know the full facts about what Clinton's team did or did not do, so I can't make the comparison legally. So I don't know. As defendant in Count 1, Act 93, defendant arranged a phone call the next day between the chief investigator and Mr. Trump, during which Mr. Trump again repeatedly falsely claimed on the victory of Georgia's election and said it was the right answer were to come out, the investigator would be praised. Sounds pretty banal. Count 1, Act 96 describes how 4 days later, the defendant personally texted the chief investigator and asked whether the Secretary of State's signature audit would speed up and be completed if they contributed. He then contacted the Georgia official on behalf of the Trump campaign, which is a political activity. Is it? Is it a political activity? Can we speed it up if we pay for it? Is it a political activity? I don't know. Not within the meaning of the Patch Act. I don't know about that. Both Count 1 and Count 28 concern the defendant's participation in the phone call between Mr. Trump and Secretary of State. During the call, defendant identified himself as the chief of staff. The only other speakers on the call were Mr. Trump, attorneys working on behalf of Trump, and officials from the Georgia Secretary of State. The defendant contradicted the Secretary of State's own conclusions about the number of dead voters in the presidential election and suggested the Secretary General make plans to meet with Trump campaign attorneys in order to see what we've got in additional meetings. Mr. Trump made numerous false statements and asked the secretary to find 11,780 votes, exactly the quantity of votes needed to reverse the election, saying, all I want to do is this. At the time, Georgia's election votes had already been certified twice after a hand recount, and Trump campaign was actively suing the Secretary of State. At no point in the call did either Trump or defendant cite or acknowledge any federal authority concerning topics discussed. Since the defendant was forbidden by law from using his authority or influence to interfere with or affect the results of the election or otherwise participate in an activity directed towards the success of Mr. Trump as candidate for president, every single one of these activities fell outside the scope of his duties, both as a matter of fact and a matter of law. However, without even considering the legal requirements of the Hatch Act, it's still clear that these activities were not taken under color of office. Employing an analysis that's considered the relationship of the challenged conduct to the claimed corresponding function of the president, another federal court found that Mr. Trump's direct outreach to state election officials were not official acts. Okay. Okay. From the District of D.C., which is not binding on this court. All defense actions here, like the actions of Mr. Trump discussed in the District of D.C. case, do not relate to the president's duties of faithfully executing law, conducting foreign affairs, commanding the armed forces, or managing the executive branch. They entirely concern his efforts to remain in office for a second term. Finally, while the defendant is expected to make a candidate-specific and positive showing, explaining his relationship to the transaction, growing out of which he's been indicted, and in showing his relationship was confined to acts as an officer, defendant has not made the showing. And he cannot because the sitting president is prescribed no role in the election of president. While the Constitution and Electoral Count Act specifically specify duties of various officials in Congress and the state level, there's no role whatsoever for the president to play, and thus no authority for the defendant can cite to claim his actions were under the color of office. Well, there's a role for the vice president to play, and he's the chief of staff for the president and might want to communicate to the vice president, so... Defendant has admitted that all of his relevant actions relating to the indictment were political activity. Yeah. An evaluation of the actions named in the indictment makes clear that all of them were intended to interfere with or affect the presidential election in Georgia and elsewhere in order to somehow transform Trump from an unsuccessful candidate into a successful one. Thank you, Jennifer, for 10 gift memberships. The activities are precisely the type to which other courts have already determined to be unofficial and therefore beyond the color of defendant's office, and he can point to no presidential authority that bring the acts within scope of his official duties. For all these reasons, the defendant fails to make a more detailed showing. He is acting under color of office for the purposes of the indictment. His notice of removal must fail. God damn it. Sorry. The mute button on my mic doesn't seem to be working right now. That sucks. To remove a case under the relevant law, a defendant must also raise a colorable federal defense. In the context of removal, colorable means plausible. In the notice, defendant raises defense of Supremacy Clause immunity. Supremacy Clause immunity requires the defendant to show both he was performing an act he was authorized to do by the law of the United States, and performing that authorized act, he did no more than what was necessary and proper for him to do. In the 11th Circuit, defendant's claim of Supremacy Clause immunity is negated by evidence that acted out of personal interest, malice, actual criminal intent, or for any other reason to do their duty as they saw it. Defendant cannot demonstrate as a plausible defense of Supremacy Clause immunity for several reasons. First, as detailed above, he has admitted that his pertinent activities were all unquestionably political in nature and thereby, by definition, outside of the lawful scope of his authority. Additionally, the activities which he assisted Mr. Trump were all unofficial activities concerning his effort to remain in office for a second term, and there's no authority for the president or his chief of staff to take any actions concerning the administration of the presidential election under either Constitution or federal law. Under the Constitution, it's the states that are empowered to select electors who will cast votes for president and vice president, and electors transmit a tally to the votes of the president of the Senate, which is the vice president. The states are left to determine the manner of elections. State officials, and not federal ones, prepare the elections, conduct them, assemble ballots, count the votes, and certify. No doubt this is why the defendant, Mr. Trump, and other co-defendants spent enormous time and effort contacting, cajoling, persuading, and otherwise interacting with state officials in the relevant time period, because the president himself has no authority of his own in the administration of the election. Federal removal is designed to protect federal functions from state interference, but this was not a risk in 2020 or 2021 and is not at risk now. Instead, these concerns attempt state functions by federal officials without authority of their own. Second, even the defendant somehow have been acting as authority under federal law rather than directly contrary. The authority would be negated by evidence of personal interest, malice, actual criminal intent, or any motivation for any reason other than due to the duty he saw it. The audio of the phone call to the secretary alone demonstrates the defendant shared a personal interest with Trump in seeing the Trump campaign achieve the goal of reversing Trump's electoral losses in Georgia. It also demonstrates the defendant's actual criminal intent in participating in solicitation of the violation of Secretary's oath office by finding votes or otherwise changing the outcome of the election. Additionally, count 1 demonstrates the defendant's explicit personal interest in these matters. He asked the state official whether the Trump campaign could pay to speed up signature verification. How that's illegal is beyond me. Like, can we pay you to speed up the signature verification process? How is that illegal is beyond me. I don't get it. I don't get it. The defendant cannot plausibly argue these activities were somehow authorized by federal law when there's evidence demonstrating his personal interests, criminal intent, and otherwise motivations. Particularly when he's admitted the activities were clearly political and tied to vigorous and tireless advocacy in favor of Trump's election. Third, the defendant cannot plausibly argue that he did no more than what was necessary and proper. For conduct to be necessary and proper, an officer must subjectively believe his actions were appropriate to carry out his federal duties, and the belief must be reasonable. As shown above, there is no authority anywhere for the president or his chief of staff to insert themselves into electoral processes of the state of Georgia, meaning none of the defendant's actions were either necessary or proper. The office of the president has no preference for who occupies it. A function of the presidency is therefore not to secure or perpetuate incumbency. The defendant points to nothing supporting a conclusion that could demonstrate why it would be objectively reasonable to believe his duties as chief of staff included acting on behalf of the Trump campaign, pressuring state officials, or pursuing unlawful strategies designed to ensure Trump's reelection. Even if there were some authority supporting defense action, violating state law for purported federal purpose must be a rare exception, and every case must be seen to be reasonably necessary and proper. It is not enough to say merely the defendant acted at the behest of or in service to the person who was present at the time. Presidents and other officials face a variety of demands on their time, some private, some political, and some as a result of duty. A claim of immunity for unofficial acts cannot be grounded purely in the identity of the president's office. There's no demonstrated basis for the federal authority related defense actions when there's ample evidence of personal, political, and unofficial tensions. Yeah. This is kind of stretching it a little bit. Finally, to the extent the defendant seeks to claim a Supremacy Clause immunity defense, could plausibly because his overt acts in count 1 of the indictment are somehow within the scope of duties and necessary and proper for their execution. Defendant misapprehends the nature of Georgia's RICO law and conspiracy generally. An overt act need not be a crime in and of itself, which is true enough, but the fact that so many of them are strictly illegal is kind of weird. Like when I was reading them, when I was reading the overt acts, and so many of the overt acts were like blatantly legal, I was like, it wasn't exactly encouraging, you know? Thus, arguing that some or even all the alleged overt acts are not criminal per se does not demonstrate that they cannot remain a part of a RICO. I'm not sure that's true. I'm not sure it's possible that if you could demonstrate that all the acts are not criminal, the result could somehow be criminal. That would be very, very strange. I'm not even sure that's possible. I'm thinking, is that possible? Is it possible that you could demonstrate that all the acts are legal, but they're still part of an illegal conspiracy? I'm not sure that that's possible or not. I'm thinking, like, the scenario would be, all right, I'm trying to think this through. It's like, okay, you want to rob a bank, and I agree to rob the bank with you, but I'm only going to do legal things as part of the bank robbery. Maybe that's conspiracy, but it's a very, very strange conspiracy. It's a very, very strange conspiracy where I'm only doing legal things in furtherance of the conspiracy. Yeah. Additionally, there are two elements to a conventional conspiracy: agreement and overt act. That overt act may be committed by anyone else in the conspiracy, and every conspirator is jointly responsible for every other conspirator. In order for a sovereign Supremacy Clause immunity defense to apply to RICO, defendants must show his actions demonstrating his participation in the agreement were authorized, necessary, and proper. Which presupposes the agreement. So it's like you're presupposing the conspiracy to prove the conspiracy, right? You're presupposing the agreement to enter the conspiracy. So it's like, okay, the agreement is illegal, but even if so, like, you don't have any direct evidence of the agreement. Like, so you're trying to use, you're trying to use some conspiracy law to, like, undermine this entire doctrine, which I'm not sure that works. Defense actions which he admitted constitute improper political activity were outside the scope of lawful duties. He's pointed to no lawful authority that would authorize his actions. He's demonstrated no basis for objectively reasonable belief his actions were necessary and proper. He has not shown participation in RICO that conspired to overturn an election, had any relationship to duties, much less how his participation in such acts was necessary. For all the reasons, it can't work. Defendant has been indicted for a jointly common plan to overturn a lawful election and for asking state officials to violate oath by altering election returns. His indictment is the result of activities taken by him solely to advance the personal election interests of Donald Trump. He can point to no legal basis authorizing his actions as part of his official duties as chief of staff, and doesn't even attempt to explain how his actions could be lawful under the Hatch Act. Defendant's actions were not made under color of law and do not support a Supremacy Clause immunity. Instead, they demonstrate his characteristic disregard for scope of duties. For all these reasons, it should not be permitted. So, okay, I guess. So, fine. All right, so let's now read the supplemental briefing. So after the court had oral arguments, the court asked the parties for additional briefing and said, okay, do I need to find that Mark Meadows has a defense as to the count as a whole? Or do I only need to find that he has a defense as to some of the overt acts? Like, what exactly do I need to find here, as a matter of law? So the judge wants the party's opinion as to which way the law goes. Which, fair enough, right? The judge is trying to decide what the law is like. Hey, what's your view of the law? So, do I need to find that they have a defense as to the entire action? Or do I only need to find that they have defenses as to some of the counts or some of the overt acts? So let's go ahead and take a look and see what it says as relates to that. All right, here's Mark Meadows' view of the question. The court has asked for supplemental briefing on whether a finding that at least one, but not all, of the overt acts charged occurred under color of law would be sufficient for federal removal. Mark Meadows answers the question yes. So if the court finds that at least one, but not necessarily all, should we remove? Mark Meadows says yes. Statutory text, binding precedent, and Hornbook law confirm a prosecution is removable if any part relates to an act under color of office. The Hornbook, by the way, is just a compilation of laws. It's also called a treatise sometimes, and there's a couple other names for it. They're great, by the way. Restatements of law, there's also called. They're great. They contain all the law on a particular subject. They're fantastic. It's like just the black letter law, basically. So he says the black letter law says yes. Removal is thus required if at least one overt act charge has a connection or association to even the outer perimeter of Mark Meadows' line of duty. Which, I think so. Two particular aspects of the statutory text confirm this principle. The federal officer removal statute refers to removal of a civil action or criminal prosecution, not parts of claims, counts, or theories. And it authorizes removal or prosecutions against or directed to a federal officer for or relating to any act under color of federal offices. Statutory text thus shows the case with removal if some, but not all, the charge content relates to the official duties. The Fulton County District Attorney knows from recent experience that if one claim cognizable is present, the entire action is removed, regardless of the relationship between the claim and the non-removable claims. So if I get this removed, the entire thing gets removed, right? So all of it gets removed. This is an all or nothing proposition. So if some of it comes along for the ride, all of it comes along for the ride. So it all goes to federal court or none of it does. The proposition is binding under relevant law from the 11th Circuit. There, the 11th Circuit addressed jurisdiction under the law and immunity under the Liability Reform Act and a defamation claim against the Assistant U.S. Attorney, who was also a candidate for judicial office. On immunity, the court concluded that under a state law standard inapplicable here, that arranging a meeting between a whistleblower and the FBI was an official act, but that leaking the investigation to the press was not. On removal, the court made clear that the entire case was appropriately removed, quoting the same language we noted above. The case law thus makes clear the court must permit removal of any, but not necessarily all, of the charged conduct relates to the official duties. Many other federal courts also agree, citing the 7th Circuit. Assuming for the sake of argument that some of the allegations do not relate to defendant's act under color of law, removal need not be justified as to all claims. Rather, the defense need only apply to one claim to remove the case. If there be a single such ingredient in the mass, it is sufficient. That apparently comes from the U.S. Supreme Court. Indeed, Mr. Meadows is aware of no case refusing removal because the action or prosecution involved a mix of official and unofficial conduct. Lastly, it is Hornbook law that the relevant law authorizes removal, even if only one of the controversies it raises relates to a federal official, and then they cite Wright and Miller, Federal Practice and Procedure. Removal is also required even if the state has charged some acts beyond Meadows' official duties, because what controls is Meadows' articulation of his federal defense, not the state's articulation of the charges. Yeah, the state might have phrased it a whole bunch of interesting ways, but, what matters is that, what matters is how I phrase my defenses, not how you phrase them. They cite a relevant case that explains that the law is an exception to the well-pled complaint rule and allows suits against federal officers to be removed despite the non-federal cast of the complaint. So we don't look to the complaints, we look to the defenses as provided. The state's extended analysis of this theory under liability under RICO is thus beside the point. The state also cannot avoid removal by charging a mix of removable and non-removable conduct. Any contrary rule would lead to absurd results. A state could charge even the most quintessential official official act and defeat it by tacking on unofficial conduct. That would reflect a narrow, grudging interpretation the Supreme Court has rejected and would invert the presumption under a federal official removal statute which favors removal for the benefit of the federal officer. Federal courts have even held that the plaintiff, or as the state here, cannot evade removal by expressly disclaiming any reliance on state acts. So even if they had said, we disclaim any reliance, it still wouldn't be enough because it's all about the federal officer's defenses. The case, therefore, could be removed even if the indictment alleges no acts by Meadows and charged only, for example, that he joined in the RICO conspiracy. So just the mere agreement, right? And an overt act by somebody else. Normally, an action may be removed only if a federal district court would have original jurisdiction, which means that any federal question must appear on the face of the complaint, and an anticipated or actual federal defense does not typically qualify a case for removal. But federal officer removal is exceptional in this regard. So normally you cannot remove a case merely because you have a federal defense, right? They're charging you under a state law. If you have a federal defense, you can still raise it in a state court. But this is an exception to the rule. Federal officer removal is exceptional in this regard. Suits against federal officials may be removed despite the non-federal cast of the complaint. The federal question element is met if the defense depends on the federal law. Here, Meadows has pled a connection to his official duties and asserted a colorable defense. That is all he needs to do. Under black letter principles, Mr. Meadows is entitled to removal. His unrebuffed testimony establishes, and one of these days, hopefully, we'll get to review his testimony in depth if the transcripts becomes available. I incidentally asked both the state of Georgia and Mr. Meadows' attorney via email for a copy of the transcript, but neither one responded to me. Incidentally, I'm not sure they necessarily saw my emails, as I'm sure they're getting many, 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 many emails. But I did ask nicely. So the state of Georgia has yet to grant my plea. So we'll see. His unrebuffed testimony establishes the broad scope of official duties as assistant to the president and chief of staff, which may be generally classified in three categories: providing the president close, confidential advice, using his discretion to gather information, including from state and federal officials, on a wide range of federal interests and potential policies to be able to advise the president on a moment's notice, and acting as a gatekeeper to the president and managing the president's time to advance federal interests. Managing the president's time was especially critical after Election Day to ensure the federal government continued to function and there was a peaceful transfer of power. Mr. Meadows also exercised more specific duties in support of these general functions. He managed the White House staff and regularly coordinated meetings between the president and state and federal officials and outside constituents, which sounds pretty right for the chief of staff. That sounds like all things that they would do. He fielded inquiries from people trying to reach the president, to the point it seemed his phone number was plastered over every bathroom wall in America. His overarching duty was to ensure the president could effectively lead the federal government and its operations. Mr. Meadows was thus on duty 24/7 and traveled with the president or sent a designee at all times. Even if the court were to conclude that some of the charged conduct falls outside Mr. Meadows' official duties, removal will be justified even finding one of the charges relates. But the record establishes that each act on the count one, in fact, relates. As to Act 5, the Michigan Oval Office meeting, Mr. Meadows considers this part of his roles as chief of staff. They refer to a transcript. And his conduct was consistent with duties and responsibilities of the roles, including managing the president's time, maintaining awareness of the matters before president, maintaining capability to advise the president or delegate others, monitoring action items that follow a meeting, addressing federal interest in a free and fair election, maintaining awareness of matters that could lead to proposed legislation or executive orders. The state presents no contrary evidence. And they just refer to the transcript, throughout. As to Act 6, text listing phone number, Mr. Meadows considered this part of his duties, and his conduct was consistent with his duties and responsibilities on that role, namely gathering information and phone numbers in particular for the president. Mr. Meadows frequently obtained numbers for the president, and this instance did not know why the president wanted to speak with the legislature. The state presented no contrary evidence. It's just like, get me the number. And he's like, okay, boss, sure. As to count 9, Mr. Meadows was not actually in the meeting, but to the extent he was involved at all, it was his role as chief of staff. He was called down beforehand to notify visiting legislatures of their positive COVID tests. His conduct was consistent with the duties and responsibility of the role, namely protecting the president's health and physical safety, and the state presents no contrary evidence. As to Act 19, Mr. Meadows did not ask Mr. McIntyre for the memo, but to the extent he was involved at all, it would have been his role as Chief of Staff and would have been consistent with his duties and responsibilities other role, including directing and supervising staff of the Office of the President in preparing memos and tasks, maintaining awareness of matters before the President, and advising the President of matters of federal law, including implementation of the Electoral Count Act. The state presents no contrary evidence, including no evidence that Mr. Meadows arranged for or attended such meetings, nor did the state introduce a memo prepared by Mr. McIntyre. As to Count 92, visiting the Cobb Center, Mr. Meadows considered this part of his role as Chief of Staff, and his conduct was consistent with the duties and responsibility of the role, including gathering information about and maintaining awareness of matters the President would likely bring up, informing and advising the President on matters of concern to manage, the President's ability to give time and attention to the President's duties, and maintaining knowledge about matters that could be subject to proposed legislative or executive orders. The states present no contrary evidence. Indeed, its witness, Secretary Raffensperger, contradicted the state's allegations and testified that Mr. Meadows did not express any objections, as far as we're aware, as to how to do the audit that was being conducted, and didn't ask anything to be done differently when he visited the audit. So, yeah, that sounds fine. As to Act 93, the President's call to Francis Watson, Mr. Meadows considered arranging this call as part of his role as Chief of Staff and did not participate in the call itself. His conduct was consistent with duties and responsibilities of the role, including arranging and staffing the President's call and meetings and maintaining awareness of matters before the President. The state presented no contrary evidence. The state did not call Ms. Watson despite issuing subpoenas for her testimony and introduced no evidence of the call itself. As to Act 96, text regarding signature verification, Mr. Meadows did not text Ms. Watson as charged in the indictment, though communicate something similar to Jordan Fuchs as part of a broader text message. Contrary to the state's characterization, the message was not a financial offer, but an inquiry about the ability to speed things up based on similar development in Wisconsin. Mr. Meadows considered these communications to be part of his role as Chief of Staff, and his conduct was consistent with duties and responsibilities of the role, including gathering information on matters before the President, advising the President, and managing the President's time and ability, giving attention to federal duties by closing out matters of ongoing concern to the President. The state presented no contrary evidence and did not introduce the text messages in question. As to Act 112, this Jan 2nd Secretary call, Mr. Meadows considered this part of his role as Chief of Staff, as conduct was consistent with the duties and responsibilities of the role, including maintaining awareness of matters before the President, setting up meetings between the President and state officials at the President's request, managing the President's time by addressing matters taking the President's attention, and impacting the ability to address matters of ongoing federal concern, and addressing the federal interest in free and fair elections. The state did not present contrary evidence. Secretary Raffensperger confirmed Mr. Meadows' limited role in the call, consistent with the audio recording introduced in evidence, noting Mr. Meadows acting on behalf of the President, making it clear he did not believe Mr. Meadows' participation or statements on the call were inappropriate, and acknowledging that Meadows did not make any request to change vote totals or make any allegations of voter fraud. Thus, based on notice of removal and the record before the court, each one of the charged acts has a sufficient connection to Mr. Meadows' official duties to support removal. But based on black letter law outlined above, the court not need reach the conclusion to permit removal. If it finds that any charged conduct relates to the official duties, that is the end of the inquiry, removal must be permitted. The court should therefore promptly permit removal. Signed, the attorneys for the Mr. Meadows. And maybe I'll send all those people emails on Monday and ask them for transcripts. All right. So that was Mr. Meadows' thought on the issue. Thank you, by the way, for Moniker, for being a member for 34 months. We do appreciate everyone who helps to join the channel, be a part of the channel, and helps to support the channel financially. It is extensively appreciated. And we appreciate every one of you who is here. Change the background lighting. That is the wrong button. That turns off the key light. That light we need. Let's try this button instead. There we go. No, I don't like the green. What else you got for me? Yeah, that works. All right, let's see. Finally, the last document, 17 pages long, on the state of Georgia's answer to the question, which, as you may be surprised to learn, is very different than Mr. Meadows' answer to the question, because who could have seen that coming? Before I move on, I just want to make sure that I'm trying to explain this as best I can, and maybe I blew past some points or didn't explain things. So I'll just take a minute to see if there's any questions about immediately what's happening, and we can press on. Crybaby says, shouldn't the White House lawyers be doing this instead of the chief of staff? Maybe, but what the question is, the chief of staff did it, so I don't know. It is Q&A time. It's Q&A time. What you got? I'll wait for you. I'll wait for you for just a moment. Do I think the charges will be dismissed? I don't know. My immediate issue is whether or not the grant to remove will be granted, and I think the answer is yes. Asking whether they'll be dismissed or not is a step beyond the immediate question I'm trying to ask. And, like I typically like to do, I only like to ask one question at a time. So the immediate question I have is, will this be removed? And I think the answer is yes, based on my best analysis. And then where we go from there, I don't know. Oh, you sent a super chat? I'm sorry. I missed your super chat completely. I'm so sorry. I don't know why I missed it. I'm a bad uncivil. I'm so sorry. Matthew Felty said, on the issue of state claiming Hatch Act violations, wouldn't that have to be determined by the federal court? Yeah, I mean, I would tend to agree, unless it's overtly obvious. But, I think Meadows is correct, that the correct way to look at this is how Meadows characterizes it, not how the state characterizes it, right? The state's going to obviously characterize it as a violation. The question is how Meadows characterizes it, and whether he characterizes it in a way that's at least colorable. So the question, and also the issue for the court, as I think, I was sort of mentioning before, the question for the court isn't, was there a violation of the Hatch Act? But the immediate question is it possible there wasn't? Right? Is there a colorable argument it's not a violation of the Hatch Act? So the court doesn't need to answer the question right now as to whether or not there was a violation of the Hatch Act. The court needs to only answer the question right now as to whether it's colorable that it wasn't, which is a much more narrow question. M169 says removal would be good for Trump. Yes, it would be good for Trump. Removal would be good for both Trump and Meadows. Less good for us because it means no cameras, which is very sad. So instead of having the most popular stream ever, because we've been looking for that stream, right? So what could possibly be better than Johnny Depp? How about Trump, right? How about Trump? The streams would be unreal. Unreal. So it would be better for them, not as good for us, because it means no cameras. But it's much better because right now this is held in Fulton County. And if this goes to federal court, the jury pool would come from the entire Northern District of Georgia, which is a third of the state. So it would go from an incredibly heavy Democratic area, Metro Atlanta, to the entire upper part of the state. So it would be much better for Trump. So some of this he might win on federal defenses, but even if he doesn't, he has a much more favorable jury pool. So, and it's a little less grandstandy in federal court. So, yeah. How can Trump keep running for president with these legal issues? Because none of these legal issues prevent him from running for president. Are you asking me legally or practically? I'll interpret your question legally. How can he run for Trump? How can he run for president with these legal issues? Because in order to be president of the United States, you have to be 35 years of age. You have to be a natural-born citizen of the United States. You have to have lived in the United States for the past 14 years. And you can't have already served 2 terms. So he meets all the qualifications legally to be president. So he can keep running for president because none of the things disqualify him from being president. There are none of the things I just mentioned. You want to ask me a serious question? Do they allow courtroom artists in federal court? Oh, sure. Yeah, they definitely do. They'll allow courtroom artists, and we'll get transcripts and stuff. It just won't be the same. Is it possible they can remove him from ballots even if he's not convicted? Well, some people are trying to remove him from ballots even though he's not convicted using Section 3 of the 14th Amendment. We covered a case recently where someone from New Hampshire was trying to do that, but to not much success. Liffy Hatfield says, could he be present with a felony? Well, let's see if you can answer your own question. Let's see if you can answer your own question. Can you be present with a felony? Let's see if you can answer your own questions. All right. In order to be present, you have to be 35 years of age. You have to be a natural-born citizen of the United States. You have to have lived in the United States for at least the last 14 years. And you can't have been present more than twice. So you tell me, can he be present with a felony? As long as it's not treason. What clause of the Constitution are you referring to there? Which is crazy because he wouldn't be allowed to vote as a felon? Maybe. Yeah, so he wouldn't be able to vote for himself. The only other disqualifying conviction is if he's found either he was impeached or removed by the Senate, which he wasn't, or if he's guilty of a rebellion or insurrection within the meaning of Section 3 of the 14th Amendment. But seeing as he hasn't been convicted of either of those things, I'm going to go with no. Could he be present from prison? Yes, but he wouldn't have to be. The federal government would say that it would unduly interfere with their office of him being present, and they'd be right. So yeah, he would. Yeah, even if he were convicted and sentenced in state court, if he became present, they would get him out of jail because him being in jail is unduly burdensome on the federal function, and so they get a writ. They get a habeas corpus writ. I don't know if strictly speaking would be called a habeas corpus, but I guess it would be. It's like, yeah, so he would have to be. He'd have to be freed from jail as long as he's present. That's a rough inauguration day on the flip end, though. At 12 noon, you got to go back to jail. That's rough. Kelly says, in my opinion, you don't think you should be able to run with a felony conviction? Okay, propose a constitutional amendment. You can have an amendment. It can be amendment number 29. No felons for president. Let me know how it goes for you. I'm fantasizing about some scrambled eggs right about now. I'm not going to lie. Kind of hungry. All right. Let's wrap this up so I can get some food. Let's wrap this up so I can get some food. All right, so let's listen to George's answer to the question that we covered from Meadows' answer earlier. Following an evidentiary hearing held on August 28th, 2023, the court directed the parties to submit additional briefing on a single question. Incidentally, I just like the way this is formatted better, but that's me. NY Renal MD for the kidneys said Newsom, who signed an executive order in rebellion against the federal government regarding sanctuary cities, seems to qualify to be strengthened through the 14th Amendment. Gives the left's logic. Thoughts? No, not exactly. I'd have to go into the specifics of Newsom's order, but as I've mentioned many times, the states and localities are under no obligation to help the federal government. So to the extent that what Newsom's order said, which is what they typically say, so to the extent that what Newsom's order said was, we're not going to help the federal government. No state official can help the federal government. No one can cooperate with the federal government, blah, 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 blah. Then that's all legal. That's all legal. The states do not have to help. They can't hinder, they can't obstruct, but they don't have to help. So to the extent that Newsom's order said, illegal immigrants are welcome in our town and we're not going to help no feds, that's legal. So that doesn't qualify, but thank you anyway. Also, since you're an MD, can you write me some scripts? Because we're currently on a quest. We're currently on a quest to get some dioxin scripts so that I can say that I'm on meth. So, how's that work for you with your DEA number? Is that something you're interested in? Call me. All right. Anyways. Is meth good for the kidneys or bad for the kidneys? If it makes you feel better, I'll take it with appropriate levels of salt. Anyways, as the count one of the indictment, contains a number of overt acts attributed to Mr. Meadows, would finding that at least one but not all the overt acts charged occur under the color of Meadows' office be sufficient for federal removal. I do like the way this is drafted better. Meth is not good for any of the organs. It's apparently good for the ADHD and the weight loss, which I have some of those things. There are a lot of skinny meth people out there, so maybe it's very good for the weight loss. I don't know. For all the following reasons, the state of Georgia responds, the answer to this question is no. A finding that at least one, but not all the overt acts attributed to the defendant would not be sufficient to authorize removal. I'm not feeling a lot of support from the MD in chat for my let's get me on meth plan. I'm not feeling a lot of love for the please prescribe me the meth. I'm going to imagine that the meth prescriptions come with extra attention from varying licensing groups, and they might want better explanation than, well, a guy caught on civil wanted it, and so I gave it. What's the big deal? But hey, on the plus side, if they come after your medical license, I will fight for you, and I'll be on meth. So I'll be really, really attentive and I'll fight really hard. For all the reasons the state of Georgia responds to the answer to this question is no. A finding at least one, but not all the overt acts attributed to the defendant would be sufficient to authorize removal. Defense prosecution was not commenced against him for or related to any act of color of office. Defense prosecution commenced because he knowingly and willfully entered into an agreement to violate Georgia's RICO Act. The overt acts alleged in the indictment, as well as the indictment charged with a violation of conspiracy statute containing an overt act requirement, are required to be pled only to demonstrate the conspiracy was at work. Defendant is charged in count one with agreeing to join the conspiracy, the plan to overthrow the lawful results of the election in Georgia. A scenario where at least one, but not all the overt acts attributed to the defendant in count one of the indictment occurred under color of office would not be sufficient to authorize removal, because it would not demonstrate that his agreement to join the RICO conspiracy described in count one was for an act related to his duties as staff. An examination of RICO and conspiracy law more generally illustrates the crucial difference between a single overt act and joining a conspiracy. Count 1 charges the defendant with a violation of the law in that he conspired and elevate to participate in an enterprise to violate the law. Subsection A1 of the statute is violated when a person together with one or more persons conspires to violate any provisions or subsection of A or B of the code section, and any more of such persons commits any overt act to the effect of the object of the conspiracy. The relevant law provides that it shall be unlawful for any person employed by or associated with any enterprise to conduct or participate in, directly or indirectly, such enterprise through a pattern of racketeering activity. The question posed by the court contemplates a finding that which illegal narcotic is best for weight loss. There's good medical advice. There's a good question of medical advice. Which illegal street drug is best for the weight loss? Is it cocaine? Because cocaine don't lie, or man, my brain sometimes. I'm just saying there's a lot of skinny meth heads and cocaine addicts, and there's a lot of skinny drug addicts. So which one is best for the weight loss? You know, it's just the things you say on stream, man, you know. The question posed by this court contemplates a finding that the defendant committed at least one overt act under count 1 outside color of office. This would be more than what was required to demonstrate the defendant's participation in the RICO conspiracy. In contrast to a substantive violation of a different statute, a conspiracy to violate the provision does not, as the language makes clear, require the defendant to commit or agree to commit 2 acts of racketeering himself. Under Georgia law, a person is guilty of a RICO conspiracy if they knowingly and willfully join a conspiracy which itself commits to a common plan for the purpose of 2 or more acts. While Georgia RICO, unlike federal RICO, requires that one of the conspirators commit an overt act, there is no requirement the defendant himself commit an overt act because each actor in the conspiracy is responsible for the overt acts taken by all other conspirators in furtherance of the conspiracy. It is well settled that when individuals associate themselves in an unlawful enterprise, any act done in pursuance to the conspiracy by one or more conspirators is legit contemplation of all. This is consistent with federal conspiracy law. Because a conspiracy and partnership crime is the gravamen of a RICO conspiracy. I do like the word gravamen. That means just the essence of. I like the word gravamen. Is permitted not upon the commission of predicates of racketeering or even an agreement to commit predicate acts, but upon an agreement to participate in the affairs of the criminal enterprise through a pattern of racketeering activity. I wasn't really very serious about the illegal street drugs, not for the least of reasons that, of course, as we're well aware, the problem, I don't know if it's necessarily the biggest problem with the illegal street drugs, but it's certainly a serious problem, is, quality control is a real problem with the illegal street drugs. You don't really know what you're getting because, it's unregulated. So who knows what's in there, right? It could be anything. Could be baking powder, could be sugar, could be fentanyl, could be anything, right? So, I've never used a street drug ever in my life. Because I'm not a fucking idiot. I've never used marijuana, for better or worse, because I'm I'm kind of paranoid because I don't know what I'm buying because it's unregulated. I don't know who you are or what this thing is, right? So it's whatever. So it was a joke. I don't know if it played off as a joke, but it was a joke. It's because okay. Anyways, I don't know why I'm explaining the joke, but that's what we're doing now. And although on the plus side for weed, as we discussed recently, The Health and Human Services recently sent a memorandum to DEA saying that weed should be rescheduled as Schedule 3. So less regulated weed on the federal level may be coming towards us all. So there's hope out there. This happened like on Friday, by the way, in case you missed the memo. We covered it on Friday's roundup. Yeah, so the Biden administration directed HHS to do a reclassification memo, and they just submitted it to DEA on Friday and recommended reclassifying marijuana as Schedule 3. So the process is underway. So there's light before us all. Yeah. And Schedule 1 makes no sense. It makes no logical sense. And as I was pointing out, like, I wasn't kidding about the fact that doctor, at least hypothetically, could prescribe me meth. It's Schedule 2. That's the joke. That's part of the joke, right? Because I'm like, why don't you prescribe me dioxin, which is prescription methamphetamine? Because methamphetamine is Schedule 2. A doctor could theoretically prescribe it to me. Because it's Schedule 2. But marijuana is Schedule 1. It's like ridiculous. Cocaine is Schedule 2. Meth is Schedule 2. All those wonderful amphetamines, also known as speed. Speed is Schedule 2. But oh no, marijuana's got to be Schedule 1 because it's more dangerous than speed, amphetamines, cocaine, and methamphetamine. It's hilarious. It's hilarious. It's so absurd. But we're not talking about meth legality or cocaine or speed or marijuana. We're talking about RICO in Georgia. The indictment alleges the defendant conspired to violate Georgia RICO, and the state of Georgia submitted evidence substantiating that allegation. The defendant coordinated and actively participated in a phone call between the co-defendant, lawyers for Trump's presidential campaign, and officials to Georgia Secretary of State's office, during which Trump berated the secretary to overturn the results of the election Trump had lost. On the call, the defendant used the pronoun we. Really? We're getting this down on pronoun usage? Maybe it was the royal we. Maybe he identifies himself as we. Why are you assuming his pronouns? Lol. And directly disputed the secretary's investigative findings regarding the number of dead voters, insisting, I can promise you there are more than that. Earlier, the defendant, so he offered a different opinion, and that's the conspiracy. Wow. Earlier, the defendant contacted another Secretary of State's official and inquired whether Trump campaign could speed up a signature audit by providing funding directly to the state. And after insisting they didn't play any role in the coordination of the slates of fake electors through several states, the defendant was forced to acknowledge under cross-examination that he in fact given direction to a campaign official in this regard. Specifically, the defendant wrote in State Exhibits 1, in which he said, we just need to have something coordinating the electors for the states, and attached a memorandum written by co-defendant Kenneth Cheesebro, recommending the organization of slates of presidential electors to meet and cast for votes for Mr. Trump in the slates that they lost. My partner's doctor fought him on the Procedural script. Really? Procedural is a pretty mild drug. I've taken Procedural. I haven't had a Procedural script in a while, although but Procedural is pretty mild. Procedural is fine. It's only Schedule 4. So like, why would you fight someone on Procedural? It's a very low it has at least in my understanding, it's a very low addictive drug. It has very low consequences. It takes like a huge amount to OD on it. It's like ridiculous how much you need to take. It's like, why would you fight someone on a Procedural script of all things, you know? Yeah. You take it for MS fatigue? Yeah. I like just fall asleep in the middle of the day sometimes. So I basically take it for, I'm not even sure if it's strictly speaking narcolepsy, but it's like, well, I just fall asleep sometimes. Basically, I get so tired. Like, just take it to remain awake. So, you know, all the rest of it. So. You need a sleep study? I've had a sleep study. I've been on a CPAP for many years. Many years. So I was taking Procedural because the CPAP was not fully working or not fully solving the problem. So I was taking the Procedural because the sleep apnea was so problematic. But yeah, I have really horrific sleep apnea, so I'm well aware. The defendant has not disputed his participation in the events. He simply argues that all of them were within the scope of his duties and occurred under color of office. The court has thus undisputed evidence of the defendant committing the act at issue, conspiring to violate RICO statute by joining in a common plan to overturn the results of the presidential election. A finding that some of the overt acts attributed to the defendant occurred under color of office would not suffice to show the defendant joined the conspiracy itself, was under the color of office, or even related to it. A case familiar to the court provides a useful example of a scenario where a federal officer's entry into a conspiracy could occur within color of office. In a case, a local prosecutor was considering filing charges against an FBI agent for agent's activities related to an attempt to bribe a local official. The attempted bribe was part of a joint federal-state investigation into local government corruption and possible federal RICO. The 11th Circuit held that any attempt to secure a bribe fell within the agent's duties as a federal officer conducting the investigation, and the prosecution was thus barred. If the agent and other had been charged with conspiracy for the coordinated plan to seek to bribe a local official, the case would have been subject to removal because the act of conspiring in the case would have been clearly committed under color of agent's offices. The circumstances of this case are distinguishable. Defendant conspired not for a purpose related to the duties of chief of staff, but to transform Trump from a losing political candidate into a winning one, no matter what the outcome of the election had been. The conspiracy did not involve a common plan seeking to fulfill a federal objective or enforce federal law. It sought to fulfill an openly personal goal of Mr. Trump that the defendant acknowledged he shared. A finding that as part of the conspiracy, the defendant may have conspired to commit one or several acts that fell within the color of office would not demonstrate he is being prosecuted for an act related to his office. As a result, the answer to the court's question is no. A finding that some but not all the acts would not be sufficient. In the scenario outlined by the court's question, the defendant would not be able to raise a colorable federal defense. Such a defense is required in order to secure removal. In the context of removal, colorable means plausible. Defendant has attempted to raise a defense of Supremacy Clause immunity, which requires him to show both that he's performing an act which he's authorized to do by the law of the United States, and that in performing the act, he did no more than was necessary and proper for him to do so. In the 11th Circuit, defendant's claim of Supremacy Clause immunity is negated by any evidence that he acted out of personal interest, malice, actual criminal intent, or for any reason to do their duty other than as they saw it. Right about now, I wish I had done the stream earlier in the day because I'm losing my energy levels for some reason. Although I have been talking for 2 hours. A finding that some but not all the overt acts occurred under color of office would not be sufficient to remove. By contrast, a finding that some of the defendant's overt acts did not occur under color of office would affirmatively defeat his attempt to remove because it would make it impossible for the defendant to plausibly raise a complete defense to the supremacy of count 1. Red Guy says, still partially confused. The overt acts in the conspiracy themselves may violate RICO. But how did they specifically conspire to violate RICO? They didn't specifically conspire to violate RICO. That is not the issue. They specifically conspired to overturn the election is the violation. They're not alleging that they conspired to violate RICO. They're alleging that they conspired to violate the election, which itself is the RICO, or a part of the RICO. And the overt acts were in furtherance of that goal. That's what the text says. Hold on. Okay, you're right. It's not written very well. A finding that some but not all the overt acts occurred under color of office would not suffice to authorize removal of a conspiracy to violate Georgia's RICO statute. Yeah, that's just not written very well. So you were a sharper eye than me. You were a sharper eye than me, which is not surprising. But yeah, the way that's written is not really written very clearly. So, good jobs. As noted above, the question posed by the court contemplates a finding that the defendant has committed at least one overt act under count 1 outside color of office, which is more than what was required to convict the defendant under count 1. This is because the state of Georgia need not prove the defendant himself committed an overt act in furtherance of the conspiracy, but only that someone had committed such an act. That person could be any other co-conspirator. However, the question posed by the court here, whether one or more of the overt acts fall outside the defendant's color of office, the state of Georgia's case would be much stronger than that. The person who committed the overt act would be the defendant. Thus, would put the requirement showing under the law that he did no more than was necessary and proper for him to do so out of reach. Any Supremacy Clause immunity premised on the argument that some, but not all, the defendant's overt act fell within the cover of his office would be incomplete and insufficient because the defense applicable only to individual overt acts does not function as a defense to the law. Given the weight of authority contrary to defense position, he will likely emphasize the permissible standards relating to raising colorable federal defense. However, while the defendant need not show a clearly sustainable defense at this stage, he cannot even show a plausible sustainable defense. Likewise, while he is not required to virtually win his case, he cannot even show that defense would make it possible for him to win his case. Supremacy Clause immunity could do neither under the scenario contemplated by the court's question. To hold a plausible defense need not be a complete defense, would reduce the test for federal removal from permissive to nearly invisible. Indeed, many federal courts have held colorable federal defense must be a complete defense, a minimum requirement so uncontroversial it doesn't appear to have ever been challenged. And then they cite something that says, thus, the court concludes a defense is colorable for purposes of determining jurisdiction if the defendant asserts it, finding facts would, in view of the light most favorable, would establish a complete defense at trial. So one court apparently sees it the other way, so fair enough. Simply put, section of the law makes it illegal for any person to conspire or endeavor to violate the law. To violate the law, one must either commit to overt act to affect the object of, endeavor to, or conspire to commit such an act. To prove the defendant conspired to violate RICO, the state of Georgia must prove that some conspirator committed an overt act. The scenario in question posed by this court contemplates the defendant himself had committed at least one overt act outside the color of office. Such a finding would demonstrate Supremacy Clause immunity could not function as a complete and therefore plausible defense. Thus, if the court finds that any defendant's overt acts were not committed under color of office, it cannot give rise to Supremacy Clause. Where am I on this thing? Page 14 to 17? Okay, we'll power through. The scenario contemplated by this court in its order seeking additional briefing distinguishes among overt acts alleged committed by the defendant, suggesting that some may fall under color of office while others may not. The state of Georgia again observes the defendant makes no such distinction. In the motion to dismiss, the defendant insists that all the alleged conduct as to Mr. Meadows relates to protected political activity that lies at the heartland of the First Amendment, and all the substantive allegations in the indictment concern unquestionable political activity, and thus, if not covered by Supremacy Clause immunity, the charges would be barred by the First Amendment. The state of Georgia has also already submitted arguments to the court regarding the interaction between defendants' admissions, the prohibitions applicable to him under the Hatch Act, and the scope of the duties of Chief of Staff. However, the state observes the defendant has characterized the gravamen of his own conduct, all of his conduct, as unquestionable political activity, which if this case winds up going against Meadows, that will probably be what burns him in the end. It'll be totally ironic if it winds up being Meadows' own pleadings that burn him. You know, he describes all of his conduct as being political. If that winds up being the thing that burns Meadows, that will be just hilarious. You know, that's a lot of schadenfreude out there, you know? Defendant was indicted not for any individual overt act, but for entering into a conspiracy to violate Georgia's RICO. Defendant must raise a colorable federal defense, not as to some overt acts, but to actual violation of the law which he's being charged, thus finding some but not all the overt acts attributable to the defendant and the indictment occurred under color of office would not be sufficient to authorize removal. Indeed, finding but some but not all of the overt acts attributable to defendants did not occur outside color of office would defeat the defendant's attempts at removal. Such a finding would preclude the defendant from raising a complete Supremacy Clause immunity and would not alter the fact that the defendant had no lawful authority to enter into a conspiracy. Even if the burden on the defendant seeking removal is permissive, is not non-existent, particularly when the case is criminal prosecution. Well, that doesn't really make sense because this only comes up in a criminal case, so you can't kind of use its own thing against it. When the evidence before the court and defendant's own admission demonstrate the conduct was not authorized or no more necessary, proper defendant cannot meet his burden. So, my view is that the court will probably grant removal unless Meadows winds up getting hoisted on the fact that he himself argued that his actions were political, and so loses it for that reason, which would be hilarious. You know, he argues that his actions were political, and therefore loses this argument. So my thought would be that Meadows is likely to get removal, but Georgia makes some decent points, and they might also be right about. It also depends on whether or not George is right about the whole thing about whether or not he needs to show an action as it relates to whether I don't even remember where it was, whether or not if he needs to show like a complete defense to like one of the charges, then he has a real problem. Although he might be able to get there. But like, yeah. So I don't know. And also it depends a lot on the judge. Who's the judge hearing this case? I forget. Who were they appointed by? I forget. So there's some problems. Can he still modify his plea to incorporate specific defenses? Not really. Not at this point, no. It's like it's too late for that, you know? You filed your stuff, let's press on, let's move. Chinese food does sound good, but I think I'll stick with some eggs, because I can make it right now. I can make eggs in under 5 minutes, and eggs sounds good. All right, I'm a little bit tired. And this analysis has been fun, but I think we're done for tonight. Just by like way of discussion, I might be trying to change the format of the channel again. The edited videos that I'm doing are not performing well enough, and we need to figure out something in order to get the channel to perform better. We're just not bringing in enough revenue right now. We're not bringing in enough super chat revenue. We're not bringing in enough revenue to keep the channel afloat. So we might try to mix up the channel, mix up some stuff. I was thinking about trying to like maybe instead of doing the morning roundups, maybe we'll stop doing morning roundups and we'll try to find like. We'll just try to find like really controversial stories that will really like inflame people's feelings and get a lot of like juice flowing. and try to deliver them that way. Better thumbnails. I'm not good at thumbnail design, and I can't afford to hire anyone to do it. Right now I'm doing, right now for thumbnails, I'm just using Canva, which, you know, is a service to design thumbnails. And I'm just using like stock thumbnail design because I don't have any creativity when it comes to thumbnails. I can't create better thumbnails because I'm not capable of it. I don't have that artistic eye to do it. So I can't create better thumbnails, and I can't afford to pay somebody. You know, when you go to thumbnail design people, they're like, they want a minimum of like $5 per. I can't afford it. You know, I can't afford it. So, you know, I can't afford better thumbnails because I can't afford it. So we might need to like just try to do more high emotion stuff, and you know, I can't, might be cost of business, but I can't afford it. I can't afford it. So if it's cost of business, that means the channel's over because I can't afford it. There's not enough revenue coming in. Charge more for memberships. That would mean canceling all the current memberships. I'd have to get, in order for me to get, for me to change the 99-cent tier to a higher tier would mean losing every single membership at 99 cents. So I guess I could do that. I guess I could lose every single membership at 99 cents and go to a higher tier membership. But people can always choose to pay at a higher membership. There's a $5.99 tier. There's higher tiers that people can join in it. But I want it to be cheap so people could afford to buy memberships for other people. But I could like get rid of all the things. Do I ever talk to Robert Guva? No. He's not really in my circle. Maybe partner with Good Logic? I don't really want to partner. I want my own channel. I want my own voice. What about basic law overviews? I don't think that would be particularly successful. I don't think doing basic law overviews will get people clicking through the button. I don't think just doing a like introduction to tort law will get people clicking that video. Do you? Do you think doing an introduction to tort law and doing like, here's the basics of tort law, like doing it 12 parts, do you really think that's going to get the clicks? You really that's going to get the subscriptions? Make the higher tiers more attractive? I don't know what to offer for higher tiers. I don't know what to offer to make them more attractive. I'm not good at coming up with that kind of stuff. I don't know what to offer. So offer 1B fish? I'd have to get someone to make them. I'd have to get someone to make them who I'd pay for that. So I'd have to get someone who could make a bee fish that I could sell. We looked into it from like Spring. We looked into it for like Spring that sells plushies, but we'd have to have some minimum order to be able to do it from Spring. I forget what the minimum order was, like 300 or something. But we have to get like 300 orders, and I don't think we can generate 300 orders at once. I don't think we have the membership to have 300 people pay for that. Whether Good Logic disagrees with an assessment of Marbury versus Madison is irrelevant. I like talking with him. I just want my own voice. I don't have to partner with someone who I agree with on everything. That would be ridiculous. Good Logic and I are friends. I'd be happy to work with him. I just don't want to surrender my channel completely. I want my own voice. Congressional hearings? I doubt that's going to do it. Well, it's something I have to figure out. I just thought I'd give you some of the ideas of where we're going. Maybe I'm not cut out for maybe I'm not cut out for YouTube. Maybe not. Maybe I'm not cut out for YouTube. Maybe the channels cannot survive. Maybe channel cannot survive. Maybe not. The economics have to work out, you know? All right, I'm going to sign off for now. Make some eggs. Because eggs are good food and they're not very calorie intensive. But I'm going to sign for now. And get some sleep and we'll go from there. Thank you, Nathan, for becoming a $5.99 on Civilian, by the way. It's appreciated. All right, I'm going to sign off. Talk to you guys soon. Bye-bye.